Hi, good morning, everyone. Apologize for the extreme delay, but I think after an entire session of being right on the dot, I've accumulated a few minutes that we can use in our late bank, but I still apologize for that. I know you all appreciate the last, we're less than 48 hours away from deadline, and so there's a lot of moving parts and everything like that. With that, Committee Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Assemblywoman Considine. Assemblywoman Gallant. Assemblyman Gray. Assemblywoman Hanson. Assemblywoman Hardy. Assemblywoman LaRue Hatch. Assemblywoman Marzola. Assemblywoman Mosca. Assemblywoman Newby. Assemblyman Orentlicker. Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here, thank you for that. And again, just a few quick reminders. Please make sure that you turn down the volume on all of your devices. We will have public comment at the end of today's meeting. Today we have scheduled 2 bill hearings and 6 work sessions, but we are going to go ahead and start with the work session. So I will ask Ms. Diane Thornton, our policy analyst, to walk us through the first bill.
Thank you, Chair. Diane Thornton, Legislative Council Bureau. The first bill is Senate Bill 38, which was sponsored by the Senate Committee on Judiciary on behalf of the Attorney General and heard in committee on May 12th. This bill revises provisions relating to offenses against children. There's one amendment proposed. The Nevada District Attorney Association proposed removing sections in the bill requiring sex offender registration or community notification, deleting Section 2, subsection 1 from the bill concerning the person in a position of authority's intent, and lastly, clarifying the definition of sexual conduct as provided in NRS 201.520. Thank you, Chair.
Thank you so much for that. Members, are there any questions? Not seeing any questions, I will entertain a motion. I have a motion from Vice Chair Marzola. Do I have a second? Second. A second from Assemblywoman Bilbray Axelrod. Members' comments? Assemblywoman Mosca?
Thank you, Chair. I want to thank the bill sponsors for meeting with me. I would have liked this to be more expansive for nonprofits as well as community groups, but after speaking with them, I'm looking forward to working on it in the interim, and I will be a yes today. Thank you.
Assemblywoman LaRue Hatch?
Thank you, Chair. I appreciate my colleagues' work on this, and I echo those sentiments that I think that this kind of thing happens more than just in schools, and I want to make sure that we are covering all of those bases, so I look forward to seeing that work.
Thank you. Assemblywoman Summers Armstrong?
I ditto the concerns of my colleagues.
Thank you. Members, are there any other comments? I will also say that I echo the same sentiment of my colleagues. This is not just an issue or a loophole that's pertaining to schools, although the bill's only addressing that. We have examples of, concrete examples of experiences that individuals have where this has happened outside of the schools, but because of the loophole, they were not able to do anything even after calling law enforcement. So it's not just based on an expectation or narrative. There have been real life case scenarios where other, Assemblywoman Mosca, you're shaking your head. Would you like to share something, or are you just in agreement? In agreement. Okay, so that we know that those loopholes have been used in other instances outside of schools where people weren't able to be prosecuted for the same behavior, and that's after calling law enforcement. And so with that, that's where the desire to expand it to cover any situation where a youth may be vulnerable and not just expecting that this occurrence only happens in our schools. So with that, I will go ahead. Is there anyone else that would like to make a comment? With that, I will go ahead and take a vote. All those in favor, please say aye. Aye. Anyone opposed? Okay, and the motion passes unanimously. I will go ahead and assign that floor statement to Assemblywoman Hardy. Thank you. Ms. Thornton, the next one, please.
Thank you, Chair. Senate Bill 61 revises provisions relating to crimes involving the deposits or proceeds of an account held in joint tenancy, sponsored by the Senate Committee on Judiciary on behalf of the Attorney General and heard in committee on May 12th. There is one proposed amendment to the measure. The Office of the Attorney General proposed an amendment clarifying that the state is required to prove each element of exploitation beyond a reasonable doubt. Thank you, Chair.
Thank you, Ms. Thornton. Members, any questions? Not seeing any, I will entertain a motion. I have a motion by Vice Chair Marzola. Do I have a second? I have a second from Assemblywoman Cohen. Members, are there any further discussion on the motion? Not seeing any. All those in favor? Aye. Anyone opposed? The motion passes unanimously, and I will assign that floor statement to Assemblyman Urick. You're welcome. Ms. Thornton, next bill?
The next bill is Senate Bill 129, which revises provisions relating to certain civil actions involving sexual assault, sponsored by Senators Krasner, Spearman, Severs-Gansert, et al. There are no amendments to this measure. Thank you, Chair.
Thank you. Members, are there any questions on the bill? Not seeing any, I will entertain a motion. I have a motion from Assemblyman Gray. Do I have a second? Second by Vice Chair Marzola. Members, are there any comments on the motion? Not seeing any, I will assign the floor statement to, well, I'm still going to assign a floor statement anyways. All those in favor, please say aye. Aye. Anyone opposed? Okay, and the motion passes unanimously. I will go ahead and assign that floor statement to Assemblywoman Mosca. You're welcome. Ms. Thornton?
Senate Bill 243 revises provisions relating to catalytic converters, sponsored by Senator Wynn, and heard in committee on May 1st, and there are no amendments to this measure.
Members, are there any questions on Senate Bill 243? Not seeing any, I will entertain a motion. Oh, everyone's jumping on that one. Can't wait to grab those catalytic converters. I have a motion from Vice Chair Marzola and a second from Assemblyman Urick. Members, any further discussion on the motion? Yes, Assemblywoman Cohen?
Thank you, Chair. I'm going to vote this out, and I know this is an issue, and I'm still a bit concerned about what I mentioned at the hearing, that I do think there are people that just have a lot of junk and do a lot of tinkering and end up with things over the years. And so the numbers that they can have of these catalytic converters before it's considered a crime does concern me, but I'll go ahead and vote this out.
Okay, thank you. Members, any additional comments? Okay, with that, I'll take a vote. All those in favor, please say aye. Aye. Anyone opposed? Again, it passes unanimously, and I will assign that floor statement to Assemblywoman Considine. You're welcome. Ms. Thornton, Senate Bill 309, please.
Senate Bill 309 makes various changes relating to health care and creates the crime of fertility fraud, sponsored by Senator Cannizzaro and heard in committee on May 8th. There is one proposed amendment to the measure. Assemblywoman Cohen proposed an amendment extending the statute of limitations for the discovery of a medical condition in a child. Thank you, Chair.
Thank you. Members, are there any questions? Not seeing any questions. I will take a motion to amend and do pass Senate Bill 309. I have a motion from Vice Chair Marzola. Do I have a second? I am going to take the second from Assemblywoman Summers Armstrong because I actually saw her hand first. So with that, all those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will go ahead and take that floor statement. And Ms. Thornton, please walk us through the last bill, Senate Bill 321.
Thank you, Chair. Senate Bill 321 revises provisions relating to crimes It prohibits a law enforcement agency or forensic laboratory from storing the DNA profile of a survivor of sexual assault unless authorized by federal law or sharing a biological evidence of a survivor. It's sponsored by Senator Krasner and heard in committee on May 2nd. There is one proposed amendment to this measure. Senator Krasner proposed an amendment that is on the following page. It essentially adds in section 6, survivors sexual assault investigation or sexual assault forensic evidence, and then it strikes language in sub 3 of section 6. Thank you, Chair.
Thank you. Members, are there any questions? Not seeing any questions, I will entertain a motion to amend and do pass. Okay, everyone jumping again. So I will take a motion from Vice Chair Marzola and a second from Assemblywoman Gallant. With that, all those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously, and I will assign that floor statement to Assemblywoman Summers Armstrong. Thank you, members, for that. We are now ready to move on to our bill hearings. We're going to take these out of order. We are actually going to take Senate Bill 417 first, presented by Senator Scheibel. And 417, and I believe you also have some co-presenters on this one?
I do. I have Ms. Ross, who I believe is on Zoom.
Okay, so we're going to go with your co-presenter on Zoom. With that, Senate Bill 417 revises provisions governing common interest communities. Senator, there she is. Senator, your hearing is open, so please proceed when you're ready.
All right, thank you so much. My name is Melanie Scheibel. I am the state senator for District 9 and happy to be in front of you today presenting SB 417. This is a Senate Judiciary Committee bill, and as the chair of that committee, I get to answer all of your questions about the bill and talk to you a little bit about its origins. Where Senate Bill 417, and I'll do that first. So let me first talk about kind of the genesis of this bill. Over the course of the last few years, there has been an uptick in harassment, violence even, or threats of violence against people who work for, manage, or volunteer with their common interest community, which is better known as an HOA. And so here in the state of Nevada, we've done a lot of work to try to develop a system that's fair for unit owners within an HOA. And we wanted to make sure that the people who work at the HOA have some, not the same, but some similar protections so that if there are unit owners within a particular community that are especially troublesome, the HOA has some avenue to hold those people accountable. And so we're not talking about people who, attend HOA meetings and ask lots of questions or maybe oppose a measure that the HOA is voting on. We're talking about people who are actually harassing, threatening, and causing harm to the people who work at the HOA and volunteer at the HOA. And I think Ms. Rock will be able to speak to a little bit more of that and what some of Olympia Properties and the CAI members have experienced. But I heard from community managers and community volunteers that people within the HOA were threatening them. They were leaving notes on their doors. They were posting where their children go to school. They were telling people to stop people's children on their way home from school and tell them that their parents were, doing bad things or bad people. And so that kind of behavior is just inappropriate in any setting and doesn't quite fall into any other area of the law because we don't want to criminalize behavior that is protected under the First Amendment of someone's free speech rights. But we did want to provide some avenue for somebody to like I said, hold those people accountable. So what SB 417 is designed to do is to allow the division of the real estate division, which oversees HOAs, to implement some restrictions that protect the HOA members and directors. So we're not talking about calling the police when somebody is harassing a community owner or an HOA representative. We're talking about being able to report them to the real estate division in order to limit the contact between that person and the representative of the HOA. You'll also see that there is an amendment, and I apologize for any confusion with the amendments. You know how this time of session goes, and you send back and forth many amendments. And the one that we want to look at is the mock-up proposed amendment 3647, and the heart of the bill is contained in section 4, which allows the HOA it allows the commission to sanction somebody who is found to be a vexatious affiant or a vexatious litigant. So this is another form of harassment that we've been seeing in some of our HOA communities, where certain owner members will ask for voluminous documentation that is not related to a relevant inquiry. And I think Ms. Rock, again, will have some examples. People asking for landscaping plans from 1993. And when the HOA representative responds, we no longer have those, not giving up and calling the office every single day to ask for the landscaping plans from 1993. And this is taking away from people's ability to do their actual jobs and respond to complaints from homeowners who maybe have a broken sewer line or a sprinkler that is malfunctioning in their front yard that the HOA is not having time to attend to because they're busy trying to track down landscape plans from 1993. So what Section 4 of the bill does is it allows the HOA to sanction that person, prevent them from filing additional complaints and requests, and it even allows them to prohibit that person from serving on the HOA board for a certain period of time. And I'd like to turn it over to Ms. Rock, if that's okay, to explain a little bit more of the genesis of the bill.
Thank you very much. Just confirming you can all hear me. I'm doing this by Zoom. So thank you to the chair and to the committee for having us here today, and particularly thanks to Senator Scheibel for hearing these concerns. I know that often you hear testimony of bad actors in the HOA realm of management or boards, and certainly that has happened, and we're not here to deny that has happened. We are here to ask there's a concerted effort to bring professionalism and to our side of the aisle, the management aisle, the volunteer aisle, the board member aisle. And to do that and to keep good people, to ask for reciprocal protections for those of us that are working in this industry and working to be diligent and good in that industry. In that, there's two parts. And so looking to the mock-up that the senator referenced, there are two key elements in that. The first section being in section 1 of that amendment, the recognition of the time spent. An owner absolutely has the right to request documentation of their own common interest community. Absolutely. And we've seen bills over the course of the last few sessions to require those to be posted online, financials, minutes, those sorts of things. 100% they should have access to that. But to the senator's point, when in a say 12 to 13 month period, this same individual makes 342 document requests for things dating back years or decades, there's no balance to their right to receive that against the right of all of their other neighbors who are paying the management company to expend tens, 20, hundreds of hours. And you don't see a lot of this, but you see one or two individuals who can consume 90% of the management's day making repetitive document requests. So asking for recognition that there needs to be some balance to that, and that that individual needs to pay for the management's hours in requesting, voluminous documentation. And so that is the first part of that bill, asking for a balance for those individuals and the neighbors who pay. Anybody who pays assessments wants their assessments to go to the management of the community on a day-to-day basis and not a historical record-keeping search. So that was the first part of the bill that I think would be helpful. And the next point to the heart of the bill in section 4 is often you see that when the management company or the board eventually says enough, we can't keep going back decades and decades or keep answering question after question after question on a particular relevant document request. Those individuals seek the intervention of the state through the Nevada Real Estate Division to file an intervention affidavit. And in some cases, we have individuals who filed 10, 15, 20 of those intervention affidavits when they don't always get every document or every answer they want. And so vesting the power in the state, not in the HOA board, but in the state to say, okay, we've reached critical mass where now you're overusing state resources and they have to serve the state at large. So placing power in the division's hands to label someone a vexatious affiant, just like happens in our civil justice system, and giving that power then to the ombudsman to protect their own state resources. And so those are two things that we think would be immensely helpful in making sure that those that volunteer or work in this industry are protected. As a final note, and I thank you all for your time, I just want to say that, there are somewhere upwards of 4,000 associations in this state, with an average of 5 board members, a community manager, and various vendors who also from time to time get harassed. And we are looking at 20 or 30,000 people who need to be professional, need to feel protected, and need to be honored to be in this community because I do think, or in this industry, excuse me, because I do think it's vital to have good communities in Nevada. So I thank you all for your time. And I hope I've given some context to the bill and the necessity of the bill, and happy to answer any questions.
Thank you for that. Just giving members a moment to see if there's any questions. First question will be from Assemblywoman Bilbray Axelrod.
Thank you, Chair. Thank you, Chair, and thank you for bringing this bill. I am just wondering, how often is this happening? I mean, I've served as a president of HOA, and I get it. There have been times where, you're like, ugh, you're kind of annoying me. But this just seems so extreme. I just was wondering how often this is happening.
Thank you for the question, Assemblywoman. And good news, bad news, right? Good news is that it's not happening with every single member of an HOA. And certainly you have individuals that are going to have different personalities. What we're looking to is invest the power in the state to recognize in these extreme cases. In my discussions with the Nevada Real Estate Division and CAI, there are maybe 15 or 20 of these incidences throughout the state that consume Assemblywomen almost 80 or 90% of a day. And so you can have one individual in an association of 8,000 who can cause, through the intervention affidavit process, if somebody files 15 or 20 intervention affidavits and your HOA has to hire a lawyer, so the corporation does have to hire a lawyer, you can be looking at 200, 300, in Southern Highlands case, almost $400,000, $500,000 in legal fees. So the good news, not a ton, but still necessary to give the power to the commission. This is not power that would rest with the management company or the board of directors. This would be power with the division in the state of Nevada to say this particular individual is utilizing too many state resources and has filed multiple unsubstantiated intervention affidavits. And that's why it's important that the power rests with the state.
Thank you. Our next question is from Assemblywoman Gallant.
Hi, thank you, Chair. So I'm familiar with this particular HOA that is, it's kind of infamous, so I understand why this is coming. And somebody that has to deal with a lot of HOAs, I see like both sides of it. And so my concern with this bill in terms of like the bullying and the free speech part of it is that when you run for office, as we know, it puts you in the public light, and people are going to be unhappy with your leadership. And so my concern is that this could weaponize, like boards could weaponize this, not particularly the one, but probably the one I live in right now. That would be something they would do, where they would weaponize this legislation in terms of like really silencing homeowners. And then also in terms of bringing in that vexatious litigant part of it. I'm curious about, one, how we protect boards from not weaponizing that against homeowners. And then in terms of the vexatious litigant, who is going to be making that determination? Are you expecting the division to do that, or the courts? Because unfortunately, I'm kind of familiar with that, and like the criteria is quite high and very limited on who gets put on that list.
Melanie Scheibel.
Thank you, Assemblywoman. And I think those are great questions. And so I thank you for giving me the opportunity to respond to that. First and foremost, we have to have free and fair discourse, both in, as you mentioned, running for office and also in our communities. I think that's what makes them better. And there is absolutely no intent to eliminate free and fair discourse. What this was meant to do, and I think you used the term, and it was good, to have a very limited situation where the state has the power. Again, I want to be very clear. This is not giving power to a management company or a board of directors, so they would have no means through this to weaponize that. Instead, what it's doing is giving the commission, as the mock-up you have sets forth in paragraph 5 of section 4, the commission, which is part of the Nevada Real Estate Division, would have the authority in a limited set of circumstances, just like the courts do, to recognize and identify someone as a vexatious affiant. And even then, they would still have the authority, or the ability, to file an affidavit. It would just have to go through the ombudsman, not the board of directors, not the management company, but it would go through the Nevada Real Estate Division. And so really this is an attempt to give them more power when they recognize an issue is utilizing excessive state resources and excessive association funds. Everybody would still very much have their ability to go to their open forums at the beginning and the end of every meeting and express their issues. There's no attempt to silence that. Hopefully that answers that question.
Yeah, I understand the public comment, and Nextdoor is definitely a big platform for expressing. So I just hope that is protected. But in terms of bringing the division and the commission and the ombudsman into this, I know there has been some concerns that the ombudsman is not necessarily like stepping up to the plate, so to speak. And so they're really pushing this on homeowners to take civil action. And I do think that the division does need to do more. And so I'm curious, how are we going to trust that they're going to actually take this new position, these new laws in terms, and like really advocate for these boards, and advocate for the homeowners that are being harassed?
Thank you for the question. I would be a little outside my scope to speak on behalf of the division themselves. I will say that I've been in the industry for 25 years, both as a practicing attorney and now as the president of a management company. I was practicing in this industry when the ombudsman was created, and I think they have endeavored, at least from what I've seen, to always be very professional and to make themselves available to homeowners. I would hope that level of professionalism would continue. And in the cases we've had, the investigators have, I feel like in a timely fashion, reached out, and I'm happy to continue to have conversations with the division through regulation on how they would manage this. But I think that being able to reduce maybe some of the consistent and persistent repetitive complaints would allow them the time to do that. But I have found them to be professional.
Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for this amendment. I think it took out a lot of the questions that I had. My question remaining, though, is on Section 1, talking about the records that are required to be provided upon request. So I notice that, and this is not new language, this is the original, but in Section 1, subs A, B, C, and D, all of those are financial statements, budgets. It seems that the intent of this section is so that people can know how their money is being spent. And so if that is the intention, my question is why we are taking out salaries and benefits as something that people can access, because presumably that is part of how their money is being spent.
Okay, a couple of questions there, and thank you for those. I believe that going back to the issue of minutes and financial statements, things about the current financial status of one's association are on the portal that is required as of the last session. And so they can always access those documents. And if they are unable to access their financial statements or minutes through the requisite portals, then we have another issue that I think is already handled by statute. This is reaching sort of beyond to the senator's comments when we receive requests for every piece of association communication, email, documentation relating back to issues 10, 15, 20, 30 years ago. For a management company to pull up a financial statement and email it, which is required by electronic format, to a homeowner wouldn't and shouldn't take more than a few minutes. So I think hopefully that answers that piece of the question. As to salaries, this was also written in part with CAI, and I believe that situation pertains when a manager is employed by the association itself, then their salaries would in fact be part of the budget. When an association is managed by a community management company, then what is paid to the company is part of the budget and should be record, yes. What that individual makes through the management company, I think, is what was looking to be protected in that section.
Quickly,
Hopefully
please.
that answers that.
Yeah, so I just want to clarify because it does say the personnel records of the employees of the association would not be included, right? Including without a limitation, contracts, and information regarding salaries and benefits. So I just want to be clear. You're saying that the amount of money they're paying total towards employees would be reported, but the amount of money they're paying each employee would not. Is that correct?
As stated, I believe it's correct. The amount of money that you're paying to the management company is on a management line item on the budget. So for instance, if you're paying ABC Management Company $10 a door, the annual amount that is paid to that management company is a line item on the budget.
Okay, thank you. We'll go ahead and move on to Assemblywoman Cohen.
Thank you, Chair, and thank you both for the presentation. I have a question. Sorry, let me go back to the mock-up. I have a question about the review by the ombudsman of the affiants and whether or not it's become vexatious. Is there judicial review of the ombudsman's decision?
I apologize. Thank you for the question. And I think the judicial review is the question that then would the affiant have the ability to seek judicial review?
Correct.
I apologize, I didn't understand the question.
Yes, yes. So for instance, if, I understand what you were saying about how this is like if someone is filing false things at court, or if they're vexatious at court, the court can eventually say they're a vexatious litigant, but there is judicial review because you can appeal those decisions that they're vexatious. So I want to make sure that the ombudsman's decision also has judicial review.
Thank you, Assemblywoman, and I think that's a good question. As I'm reading the way that it is written in the mock-up, it is actually the commission and the hearing panel, which is a panel of 9, that makes that decision. Once you've been through that administrative process, I would argue that then you could seek judicial review if you took umbrage with their decision as a panel of 9. It's not the ombudsman, at least as I'm reading the new mock-up, it's not the ombudsman that makes that decision.
Okay, but, all right, and I'm sorry if I misstated, if I should have said commission instead of ombudsman, but is there judicial review of the commission's decision?
I would believe, as is the statute already exists, if you disagree with the decision of the division, the panel of 9, then you can seek an appeal to the district court, is my understanding of the process.
Yes, and legal confirmed that is correct.
Okay, thank
So
you.
our next question is
Thank
from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you, Senator, for bringing this interesting piece of legislation. I'd like to kind of tack back to the question that was raised by my colleague regarding personnel records. Hold on, I'm trying to get back to where I was. Just one moment, please, trying to take notes and do this at the same time. I too am concerned about the limitation that you all have placed here on employment contracts. So if I'm paying monthly fees and I'm part of this association or this organization, are you telling me that the homeowner does not have a right to know what the employment status is, or any of the details of the people that they are paying for who are running this organization? It just seems not very transparent, and so I understand you want to protect privacy, and I think there's a way to do that without letting out too much personal information. But I am concerned that you're hiring a contractor and the contracts are not available. Can you please speak to that?
Absolutely, and thank you for the question, Assemblywoman, and I do think that requires some clarity here. Contracts are absolutely available. If the contract is between the association, that corporate organization, and a management company, another corporate organization, those contracts are absolutely available to the homeowners, and that is protected already by statute. Homeowners are allowed to have those contracts. So it is not an intent to stymie that. And in truth, my management company is contract as a management company. So I don't particularly have this issue. I think we're talking about associations that contract with individual employees, or when homeowners are asking for the contract between me and my employees. There's no privity of contract there between the homeowner and the individual I'm hiring. So, but they absolutely get a right to the contract between their HOA and their management company. Anything to which they are a party, they have access to. And maybe my colleagues can speak better to that issue if I'm not being super clear on that. I will that doesn't pertain to how my, that portion of the bill was a CAI portion. So I do think there are members of CAI, or we can get you clarity on that. May be better suited to address that particular issue. But I most certainly understand what the committee is concerned about, and homeowners should most certainly have access to any contract to which they are a party.
Thank you, but that is not what this says. This says employees of the association, not a contract with an outside agency. So these are people who are being paid directly with the fees that are being assessed to the homeowner. And the language is saying employees of that association, their employment salaries and things are not available for people to know, but they're paying for them. So who's determining how much someone gets paid, whether it's a fair and equitable salary? That's where I'm having an issue. Is that you're speaking of a subcontract where the association has hired you or your company to do some work. The language that is in this bill is speaking to people who are directly employed with the money that I am paying as a homeowner. I think that's different. I think there has to be protection of personal information, but everybody can't be a secret, especially if they're a direct employee. There has to be some type of clarity and transparency on how much we are paying the people who work for us. And I think that's, that's all I have. Thank you.
Thank you. Agree completely, and we will work to clarify that.
Okay, thank you. And so with that, not seeing any additional questions, I will go ahead and open it up for testimony. So anyone here, we'll start in Carson City, that would like to testify in support of Senate Bill 417?
Good morning, Madam Chair and Committee. For the record, Garrett Gordon on behalf of the Community Association Institute, and we support the bill and the amendment. Thank you.
Thank you so much. Is there anyone else here in Carson City in support? Not seeing any. Is there anyone in Las Vegas that would like to support Senate Bill 417? Not seeing anyone. Broadcasting, will you open the lines, please?
To testify in support of Senate Bill 417, please press star 9 or raise hand in your Zoom window to take your place in the queue. Caller with the last 3 digits 935, please press star 6 to unmute your phone.
Hello. My name is Larry Hartman, and I live in Las Vegas, Nevada, and I am a community association manager for a large-scale master plan community in Henderson, Nevada, and I'm also a board of directors for a community in Las Vegas, Nevada, and I'm in support of SB 417. This bill will allow community associations to recover actual costs for records requests, thus ensuring all members of the association are not bearing the cost for these requests. Matter of reference, so my association where I serve on the board of directors is very small, and so as it stands right now, our recovery cost is $10 per hour for individuals that would like to review association documents. However, if the actual cost of that is $18 an hour, then every homeowner in my community will pay $2 an hour for every hour that those documents are reviewed. Thus, it will impact our assessments in the future and also affect individuals' ability to purchase within the community. Also, as a community manager, I've seen how records requests can be weaponized and utilized as retaliation for decisions that the board of directors of a common interest community have taken. My teams have received multiple record requests from the same unit owners, some requesting records spanning years, if not decades, along with subtle differences in the documents being requested just to create chaos and punish the association for the wrongs the unit owner perceives were done to them. As a community manager, I'm here to provide a service to all members of the association, and I'm expected to provide those services consistently across the board as a fiduciary. My team and I also deserve not to be subject to any forms of harassment or intimidation from a unit owner, tenant, guest, or board of directors and clients. We are hopeful that this bill will continue to provide additional protections and recourse against offenders to ensure the association's workplace is a business environment and everyone is expected to conduct themselves in a professional decorum. Further,
Sir, I'm
in
going to
reference
ask you to wrap up
the
your
questions
comments.
pertaining to- I am done. Thank you.
Thank you so much. Broadcasting, next caller.
If you have recently joined and would like to testify in support of Senate Bill 417, please press star 9 now to take your place in the queue.
Yeah, hi, am I testifying?
Yes, you are. This is for people who wish to testify in support of Senate Bill 417.
Yeah, thank you very much. My name is Rhonda Tyson. I'm the president of a 100-unit condominium association in Reno, Nevada. I have so served my community consistently for the last 5 years. However, my journey to serve my community started almost 10 years ago when I was first elected to the board, but resigned after 3 months because of the constant harassment I was getting, including middle of the night contact, stupid and uninformed. During the period of time between my service on the board, that same individual put out an email that he wished to be widely distributed that advised everyone that he had a concealed carry permit and we should be aware anytime we saw him on property that he was armed. When I decided to run again for the board, I actually seriously considered getting a bulletproof vest to wear to meetings. That's how seriously I took that harassment. Other forms of harassment have been the guy who put a smiley face in the hallway outside a board member's apartment that was tagged with the words, "God hates fags." A lot of the harassment is a lot more subtle than that. I had one guy who, in the period of a year, filed 4 intervention affidavits alleging the same set of facts, each time determined to be unfounded. He also submitted a claim to our insurance company, which again was unfounded, but caused us an increase in our D&O premiums, not to mention the attorney fees. Last example I want to share is the guy who is trying to get the board recalled, not for any legitimate reason, but because he himself has been fined for doing illegal plumbing work in his apartment without a permit, without a licensed plumber, and that caused a flood into the unit below.
Ma'am,
Of
I'm
course,
going to ask you
that's
to wrap up your
confidential
comments.
information.
If you could wrap it up.
Right. It's simple. Yeah, if you want good people to serve, you need to protect us. So please, please pass this bill.
Thank you, ma'am. Next caller.
Caller with the last 3 digits 515, please press star 6 to unmute your phone.
Thank you, Madam Chair. For the record, my name is Phil James, P-H-I-L-J-A-Y-N-E-S. Between 2006 and December of last year, I was the director on the Southern Highlands Board or Master Association. I volunteered many hours of my time to hold this position. The reason I did not rerun for my position was because of one individual. I essentially didn't have time for his nonsense. For the assembly person who essentially said, you ran for the position and you put yourself in that position, as all of you elected know, if a constituent harasses you, you can ignore them. At the most, you'll lose a vote or two. This is about the people who actually work for the HOA. By law, they have to deal with these individuals. They can't just walk away like I did. And ultimately, the people who pay for it are the actual homeowners. As a homeowner, I'm paying for all those legal fees, and we need some protections against that. Thank you.
Thank you.
There are no other callers choosing to testify in support at this time.
Thank you so much. With that, I will open it up to opposition testimony, starting here in Carson City. If there's anyone that would like to oppose Senate Bill 417. Not seeing anyone. Is there anyone in Las Vegas that would like to oppose 417? Broadcasting, will you open the lines?
To testify in opposition of Senate Bill 417, please press star 9 or raise hand in your Zoom window to take your place in the queue. Caller with the last 3 digits 032, please press star 6 to unmute your phone. Caller with the last 3 digits 032, you are unmuted and may begin.
Yes, my name is Samuel Covelli. I'm in Las Vegas, Nevada. I'm speaking in opposition to this bill, and if I may offer very briefly, page 5, subsection 8 and 9 should stay with the original language of this bill. There's no reason to, number one, there's no cap on what this, right now it says $10 per hour. They want to strike that and make it unlimited, basically. There is no cap, which is wrong. Who makes the determination on how much a homeowner is going to pay for information that they're entitled to have under statute? Also, page 6, subsection 2, this proposes this language needs to be eliminated because it conflicts with 31175 section 2. It takes the cap off on what period of time an association's management company or the board has to provide you with documents that currently under 31175 they have to provide you with within 21 days. This removes that requirement, so that's in conflict with 31175 section 2. The language as far as bullying is total overkill. This gives a lot of leeway. It's vague, it's ambiguous. It gives a lot of leeway to board members, unscrupulous association attorneys, and managers to silence people. There's just, if this was in our political life, this bullying section, Trump would have been in jail years ago. I probably shouldn't say that, but that's the way it is. In closing, this bill is overkill.
Sir, can you wrap up your comments, please? Sir, can you wrap up your comments, please?
This bill is overkill. I will. This bill is nothing but overkill. It puts fear and intimidation on a homeowner. The bill as presented does not reflect what the testimony has claimed as far as its intent.
Thank you so much.
There are no other callers choosing to provide testimony in opposition at this time.
Thank you. Is there anyone here in Carson City that would like to testify neutral? Not seeing anyone. Is there anyone there in Las Vegas that would like to testify neutral? I believe someone is approaching.
Good morning, Madam Chair, members of the committee. Sharat Chandra, Administrator for the Real Estate Division. Just here in neutral and happy to answer any questions.
Thank you. We don't have any questions. Do you have anything else you would like to get on the record?
Thank you, Madam Chair. Sharat Chandra for the record. No, the Ombudsman's Office, as you all folks know, there are about 3,600 HOA associations. That's about a little over 600,000 units, so there's plenty of activity that the division goes through. There's a process through the Ombudsman's office to work through a lot of the complaints. So essentially, it's all, what we try to do is we try to resolve it. There are different avenues to do this. It's important to remember that we are guided by statute and by regulation. We just can't do everything for everybody. So we work within the confines of 116 and 116A. There's an ADR process, which is the alternate dispute resolution process, and RS 38. So there's a process for that. If folks have issues with their CCNRs, that is the avenue that is provided. So there, we are just the intermediary. We make that, we facilitate that process. And then if people can't resolve this, then they can take it up with court. I know there were questions about judicial review. Our process is, we would make a case for whatever the complaint is, and then that goes in front of a 7-member commission, Common Interest Commission, that's appointed by the governor. It's a three-year term, and they would adjudicate on these matters. And again, that is available for judicial review. The AG's office represents the division, and that's how we take disciplinary cases through the process. Again, it is important to remember that board members are volunteers, and so what we do at the Ombudsman's office is we also have a huge educational section that really tries to educate people and try to give them the tools that they can use on the board. There are management companies. These folks are professionals. They're licensed under 116A that actually help associations. But ultimately, the board is elected by your homeowners that represent that association. So there is a lot of moving parts to this, but I just wanted to put that on the record. Thank you.
Okay, thank you so much for that. Is there anyone else in Las Vegas that would like to testify in neutral? Not seeing anyone? Broadcasting, will you open the line?
To testify in neutral to Senate Bill 417, please press star 9 or raise hand in your Zoom window to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Okay, thank you so much. So with that, I will welcome Senator Scheibel is waving. She has no final remarks. I will go ahead and close the hearing on Senate Bill 417. With that, I will open our next hearing, which is Senate Bill 335, sponsored and presented by Senator Orenshaw, Jonathan Norman, and Aaron McDonald, who I believe is on Zoom. And Senate Bill 335 revises provisions regarding real property. I also believe there was a last-minute amendment sent in again this morning.
Good morning, Chair James Orenshaw. States.
I'm sorry, Senator, I just want to confirm. There is that, okay, and do we have copies of that amendment? Has that been provided to members?
Chair's indulgence.
Yes, please.
There is an amendment that Ms. Elliott sent to me, and I
Okay,
don't
because
know
there's
whether members have or not.
there's 2 amendments that we've been made aware of.
That's correct, Chair. There's the amendment Mr. Norman submitted, and then the amendment Ms. Elliott submitted. Her amendment is a 1-page amendment.
Okay, so both of those are posted on Nellis at this point, so I just want to make sure, and please address both of them in your presentation.
Thank you, Chair. Good morning. James Orenshaw. I represent State Senate District 21 down in Southern Nevada, and I thank you very much for hearing Senate Bill 335 today, Chair and members of the committee. As most of you know, I'm a native Las Vegan, and but born and raised down in Southern Nevada. I love that part of the state, love my hometown. And as most of you who come from our part of the state know, our unhoused brothers and sisters, I think we've never seen such a large population of folks who have not been able to stay in their homes. Senate Bill 335 is a small attempt, but I think an attempt that can help try to keep people in their homes and not be evicted, land back on their feet. These are folks who are seeking rental assistance. I believe we've certainly worked on quite a few amendments over in the other house. We're proposing some amendments now. I believe it's a balanced approach that tries to keep people housed, but also protects landlords. I've been very lucky to work with some great public interest attorneys like Mr. Norman, the gentleman down in Las Vegas, and I don't want to say your name incorrectly, who've been, working with judges and all the other stakeholders and trying to craft a very, very good bill that I think will help our constituents. With your permission, Chair, if I could turn it over to Mr. Norman, then Ms. Elliott, then I'm happy to answer any questions.
Chair, members of the committee, Jonathan Norman with the Nevada Coalition of Legal Service Providers. Aaron McDonald is my colleague down in Las Vegas. He runs the housing team at the Legal Aid Center of Southern Nevada. He's primarily here to answer any questions that get into how this process has worked up until this point. If it's okay, Chair, I'd like to just give an overview and some background and then walk through the bill. The bill does two things. One, it creates an extension of time for tenants to pay or quit and a stay of proceedings in non-payment of rent cases under very limited circumstances. And number two, it allows justice courts to create eviction diversion programs should they choose. Pending rental assistance in 2021, and this is the defense that was created by AB 486 in 2021, was presented by Assemblyman Yeager, and it created a defense for tenants who had a pending rental assistance application. The defense, coupled with historic rental assistance, put nearly $500 million into landlords' pockets, keeping tens of thousands of Nevadan families housed during the pandemic. 70,000 families in Clark County alone were kept housed because of this program. This defense sunsets on June 5th of this year. The importance of giving time for tenants to be evaluated for rental assistance before being evicted is vital. Though we were out of the pandemic, we are not out of the eviction crisis. COVID-era rental assistance is behind us, and new sources of rental assistance will be a fraction of the amount of the COVID-era assistance. We must use that money wisely, targeting our fixed-income seniors, those with disability, and in my view, deploying those dollars to ensure that families who have faced emergencies where they missed rent for 1 or 2 months aren't left in a position where they will become homeless. Those are the two rental assistance programs currently being operated in Clark County. And just as our rental assistance programs need to be more targeted, so does the tool we use to ensure tenants do not get evicted and then receive their rental assistance after being evicted. The second part of the bill is eviction diversion court, allowing local justice courts to set up eviction diversion. In 2021, the Department of Justice directly called on state courts to use eviction diversion strategies and programs to prevent mass evictions from becoming a national crisis. The White House, together with the Department of the Treasury, hosted a summit on building lasting eviction prevention reform in August of 2022. The National Center for State Courts has committed to court-led eviction diversion programs by creating the Eviction Diversion Initiative Grant Program and convening the advisory panel on this matter. I'll get into this in a little bit, but the Las Vegas Justice Court was one of the first courts in the country to apply for this grant and receive it. The ABA and Harvard released a report in June 2021 called Best Practices for Court-Based and Court-Adjacent Eviction Prevention or Diversion Programs. The ABA 10 Guidelines for Residential Eviction Laws. Guideline number 5, courts should require landlords and tenants to participate in pre-litigation diversion programs focused on maintaining housing stability. At the White House Summit in August of 2022, the findings included the fact that 180 jurisdictions in 36 states have developed or enhanced eviction diversion programs. Texas has a court-led statewide interagency eviction diversion program. Chief Justice Nathan Heck of the Texas Supreme Court was recognized by the Department of Justice as a leader and early adopter of eviction diversion as a vital solution to the imminent threat of an eviction crisis. The Las Vegas Justice Court applied so when we understood that CHAP, and CHAP is the large pandemic era rental assistance program was coming to an end, but the need for rental assistance hadn't ended. So we wanted to focus on our most vulnerable members of our community. So a working group started in January or February of 2022 to discuss what would be kind of a glide path out of the pandemic era rental assistance. So stakeholders began meeting at times weekly. Every 2 weeks, we had a 6-hour meeting to talk about eviction diversion and a continuation of some type of AB 486 defense. The Las Vegas Justice Court applied for the National Center of State Court Eviction Diversion Grant and received it. The Las Vegas Justice Court ended up launching that program. It's had, figuring out new programs always takes some time, so I think the program is just getting up and running. And that program hinges upon having something in statute. Right now, we have two things. We have the AB 486 defense, which sunsets on June 5th. Without a defense like that, we cannot have eviction diversion programs, or a statute like this bill that allows for justice courts to develop eviction diversion programs. In December of 2022, the Nevada Supreme Court heard arguments on whether the adoption of local rules to allow eviction diversion in the Las Vegas Justice Court, and the Nevada Supreme Court allowed the development of those rules, and that's what's enabled this program to launch. But it needs statutory framework to continue beyond June 5th. So with that, I'll dive into the bill. The bill is a rainbow, so what I'm going to do is just try to connect sections as we go. So I'm just going to skip to section 9. As you can see, we did a lot of amending. Where we had amendments is, I think, in the Senate side. Judge Zaragoza, who was formerly the chief judge of Las Vegas Justice Court and had a big role in the handling of evictions in Las Vegas Justice Court, which they handle 70% of the evictions in the state. She, in her testimony on the Senate side, said that the bill would, I don't know if she said it was catastrophic or it would cripple the ability of the justice courts to function. So obviously we went back, worked with her and the other judges to make the bill work for the court so that it is something that they can manage, and that's why we have so many different colors on the page. So section 9, in any summary eviction proceeding pursuant to 40.253. So 40.253 is unlawful detainer, supplement, and so this is when somebody owes rent. So they're past due on their rent, and that's the basis of the eviction. So this doesn't reach other types of evictions such as nuisance and lease violations. So we're talking just about non-payment of rent cases. And so it sets out that the justice court can stay the proceeding. They must stay the proceeding and grant an extension of time for that pay or surrender. So remember, when they get that notice, you have to pay your past due rent or you have to vacate the premise. So what we're doing is creating the ability for they must extend it when there's a pending rental assistance application. And then we set out, and this starts in subsection, in A of that section, we put parameters on this. And a lot of the questions on the Senate side were, how are we going to limit this so we don't have these horror stories of 8 months for evictions to happen? So we tried to really narrowly tailor this to meet the needs of the most impacted in our community. So the tenant must have submitted the application for rental assistance before the date on which the landlord filed the affidavit of complaint, or before the date the tenant filed the tenant affidavit, whichever comes first. Whichever comes last. Thank you, Assemblywoman. So we have that in there because obviously working its way through this body is also AB 340, which switches the order. So in drafting that, I wanted to make sure that whether the law in the order of eviction stays the same, or if the law changes, that would be okay. They have to provide proof to the court that the application was submitted, and they must have timely filed the answer. So they have to have filed an answer with the court where they request the extension of time and stay of proceedings. And then, so I'm moving to the top of page 3 in the amendment. We're still in the same section. If they do those things, the court must stay the proceeding. The landlord may file a motion. So there are circumstances where a landlord, where it may put them at financial risk if the eviction is stayed for up to the 60 days. So again, we tried to put some parameters on that. So then we lay out what those would be. If the landlord files a motion, and it has to be to lift the stay, And then on the top of page 5, we go into what the landlord would have to show in evidence. So if the landlord is not able to evict the tenant, they face imminent risk of foreclosure or a realistic threat of foreclosure. I think we changed it from imminent. And then we tried to set out what that would look like. What should the court look for in deciding if the landlord is at imminent risk, or sorry, at realistic threat of foreclosure? And then I noticed just a typo. There should be an or at the end of 3 months delinquent on the mortgage due to the non-payment of rent. So then, or the tenant submitted an application for rental assistance in bad faith, or the tenant will not qualify for rental assistance, or the rental assistance combined with any presently available tenant funds would not cover the full amount of defaulted rent should the application be granted. The reason that's important is right now in Clark County, for example, the rental assistance program is not more than 2 months. Well, what if the tenant owes 3 months? What happens if the rental assistance is only going to cover 2? The tenant needs to show that they have the ability to pay that third month, because we don't want to create a situation where we've gotten somebody. The idea behind that is not to get somebody 2 months down the road and we're going to be having another eviction. We want to maintain housing. And then finally, well, not finally, in this section, number 5, number 5 sets out how long the stay has to be maintained, if not lifted by the motion. And then what happens if the rental assistance is granted? And then moving on to the top of page 6, we try to lay out what happens in situations where either the tenant or the landlord has acted in bad faith and create another action that a remedy can be pursued. In the middle of the page, we're again narrowing when a tenant can narrowing it, so for when an application is no longer pending. And again, this is to try to weed out cases where we're not going to maintain housing or where the application is not going to be granted. So in section 10, in any summary eviction proceeding pursuant to NRS 4251, failure to perform condition of lease. So this section is the only section where we mention something beyond non-payment of rent. The reason is we want to put a guardrail in case a landlord is creating a pretext to evict a tenant. So if the tenant's behind on rent and they want to avoid being put into this defense, they could file it for a pretextual lease violation. So this section is attempting to address those instances. So if you look at A, when a tenant is in default on rent prior to the service of notice to surrender, they have submitted the completed application, filed their answer, proof to the court on which the application was submitted, and said application is deemed complete by the government entity. And then finally, the alleged failure to perform a condition of the lease is not material to the lease. So, I've asked the courts how they would deal with this, and they said, you could have in a lease that the garbage cans have to come in on Wednesday morning, right? And the garbage cans don't come in until Thursday. That's a lease violation, but should a person be evicted for that? If the true reason for the eviction is that they have rent due and owing, and that lease violation that the landlord has filed is merely to circumvent this program. And then we have on page 7 the definitions of pending application for rental assistance. And again, this was an attempt to narrow the number of people who are going to be able to get on this program so that we're not having applications that aren't going to be granted sitting out there. And then there's a definition of rental assistance, and I'm just going to briefly turn this over because I think this is where Ms. Elliott's amendment comes into play. So this is a definition of rental assistance at the top of page 8.
Thank you, Mr. Norman. For the record, Mindy Elliott with Flynn Judici Government Affairs, representing the Southern Nevada Regional Housing Authority, the Nevada Rural Housing Authority, and the Reno Housing Authority this morning. And as Mr. Norman alluded to, first I want to thank Senator Orenshaw for his patience as we work through this very simple amendment, which is up on Nellis. And the amendment, we've added a new number 2 under section 9B, and it states it does not include income-based rental assistance pursuant to 42 U.S. Code 1437F. And the reason that that is important, as we didn't want someone that has simply applied for a voucher to be included in the definition of federal. Just by way of reference, the current wait list for a voucher in Southern Nevada is approximately 38 months. And the current wait list in the Nevada Rural Housing Authority is 23 months. We wanted to make it clear that the reference to the federal funds did not include this, the vouchers. As we didn't want certainly didn't want the landlords to be waiting 38 months for there to be resolution on whether someone was going to receive a voucher or not. So it's a fairly simple, straightforward amendment, and we very much appreciate Senator Orenthal working with us to make sure that this was crystal clear. Thank you, and I'm available for questions if necessary.
And then, Chair, is it okay if I continue with the, and so then section 9.5, and just to back up for a second, so we have two separate things. We have courts may establish these eviction diversion programs, but for example, in Clark County right now, we have eviction diversion program operating in Las Vegas Justice Court. We do not have one operating in North Las Vegas or in Henderson, right? So the reason we have section 9 is we want people in areas that do not have an eviction diversion program to still be able to be eligible for rental assistance and to not receive that rental assistance after they've been evicted, right? So that's why section 9 exists, and then section 9.5 is enabling language that allows a justice court to establish an eviction diversion program. For some background on the eviction diversion program in Las Vegas Justice Court, Judge Saragosa did a presentation to the interim committee, I believe that was in May of 2022, about the diversion program. How the program is designed to function is and I'm going to talk about, that's the program that's been stood up and is just getting rolling, is when the complaint's filed, the tenant gets 2 dates. One is their eviction date, which is set no sooner than 60 days, so it'll be set sometime after 60 days. And then 2, they get an eviction diversion meeting. At the eviction diversion meeting, the idea is they're going to be connected to social services to see what additional needs the family has. Is rehousing going to be something that we need to look at? Are we going to be able to maintain housing through rental assistance, connect them with legal aid provider to determine if there are any legal defenses, or if there's another reason the tenant has been unable to pay rent. For example, they have a lot of medical debt that they've been servicing, and maybe a bankruptcy is appropriate. So that is when I think of diversion program, I think it's connecting those people with other resources that can help get them caught up on their rent and then get them in housing that they are able to maintain. And with that, I think I will send it back to Senator Orenthal. Thank you.
Thank you very much, Chair. Thank you, Mr. Norman. Thank you, Ms. Elliott. And I'm happy to answer any questions.
Thank you so much for the presentation. And we do have a few questions. The first one is from Assemblyman Gray.
Thank you, Madam Chair. Thank you guys for the presentation. With regards to the rental assistance programs that are available, which ones are available now? How many months do they provide, and how long does it take for them to be processed, for the applications to be processed?
Jonathan Norman with the Nevada Coalition of Legal Service Providers. Currently in Clark County, there are 2 rental assistance programs, and so broadly, one is for seniors or someone with a disability who's on a fixed income, and by fixed income we mean Social Security disability. I think there were some people who had, pensions who applied. They said we get the same amount every month. So it's not for them. This is for people who are on Social Security disability, have faced a rent increase, and their income obviously hasn't risen, right? So that's one of the programs operating. The second program is designed for people who are no more than 2 months behind on their rent. So you have to be 1 or 2 months behind, and the idea is if you had an emergency, You have shown that you've been able to pay your rent, and if we get you righted, so if we get you current, you're gonna be able to pay rent going forward. And I believe that that program, you can only access it once, so it's a one-time shot to get a family back on their feet, and so they're not evicted. And I'll see if my colleague, Mr. McDonald, has anything to add, because he's in the granular level in Clark County. Thank you.
Yes, thank you for the question, Senator Gray. No, that's correct. So there are two primary rental assistance programs under Clark County Social Services. And really the idea is to keep elderly and disabled folks housed, and then allow folks who had that temporary hardship to cure the rental arrears and resume paying rent going forward, but only allows for payment of 1 or 2 months in this limited circumstances. So very much more narrow types of rental assistance than what we historically have had and what we had during the pandemic, but we still expect those programs to be needed and to keep folks housed when they're facing these types of hardships.
And then if I could just add one more thing. So when we think of the pandemic era rental assistance, you know, I don't know if we have anybody from the county, but the burn rate for Clark County during that time was, you know, it could be $15 to $30 million a month of rental assistance. The burn rate for, you know, these programs, I think IFC designated $15 million in October for Clark County, and I think there's an appropriation bill for $22 million for each year of the biennium. So we're talking about, I think we're scaling it back to like maybe 12% of the pandemic era rental assistance.
Thank you. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair. It's good to see you all. A couple things. I'm going to be dealing with on the rainbow, if I can find it correctly. On page 5, line 42, it looks like it's part of section 9, used to be old sub 2. But first of all, a little background. I'm sympathetic to this. I grew up in this sort of situation. I think many have heard my story. I moved 17 times in 18 years as a kid, single mom. I know what eviction looks like. And that being said, I still have issues because it is such a complicated picture. Eviction, getting behind on the rent, there's multiple factors, and all circumstances are individual. And I know in my situation with my mom, not necessarily any of this would have helped the outline issues that are going on in a person's life that get you to a position where you're struggling to get your rent paid. My issue is in the language that says on line 42 of page 5 of the amended version, evidence that the landlord faces a realistic threat of the foreclosure of the premises if the landlord is not able to evict, if they're behind on their mortgage, that sort of thing. My question is, you know, some people, they don't have a mortgage. There's mom, pa, folks that own one rental property, maybe a couple, that they've really worked hard to get in their life. And that they don't have a 401k, and these rents are their retirement or their ability to pay for their children's college. So I have concerns that just because a property might be, you know, for those that have a mortgage, what about those that don't have a mortgage? How do we know what they do with their funds? And are we going to ask them to now be accountable to the state? How do you spend your rents in order for you to qualify for maybe an exemption on being able to evict?
James Ornshaw, Senate District 21, through you, Chair, to Assemblywoman.
Please go direct.
Oh, thank you. Assemblywoman Hanson, thank you so much for the question. As I look at the language of the proposed amendment on page 5, certainly I see one of the potential factors that a landlord could present to the court as evidence of that realistic threat being the delinquency on the mortgage payments, but I also see the tax or utility lien being placed on the property. So I think that would also protect a landlord if they don't have a mortgage on that property, but they are still in a financial hardship situation. As to the other factors, I think that if the last section on diversion courts passes and we see more of these eviction diversion courts established, that I think tenants in trouble might get some of these wraparound services that are mentioned in the bill, and hopefully, be able to make the landlord whole and to get back on their feet. That's my hope with the bill. And if I missed anything, please jump in, Mr. Norman or Mr. McDonald.
Jonathan Norman, for the record. I guess the only thing I would add is, during the CHAP program, we had tenants who were eligible for 18 months of rental assistance, and some of those cases could stretch out quite long and put landlords in a vulnerable position, right? So if you're 5-6 months, you haven't gotten a rent. We don't have those programs now, right? So we're talking about 1 or 2 months for the eviction diversion court section. They can extend that period of time for no more than 60 days. So hopefully that, coupled with the hardship language, strikes that balance where we're considering where the landlords are coming from, but also where the tenant's coming from, and trying to get those people where we can maintain housing. So thank you for the question.
Yes, and one last comment. So Assemblywoman Hanson, this bill actually will help the mom and pop landlords. So like Mr. Norman said, there's a very limited period which the rental assistance application will be reviewed. But what we're hoping is that these tenants will receive rental assistance to make the landlords whole. So rather than evicting the tenants and trying to pursue the tenants through small claims court or through hiring counsel and suing in justice court or district court for the back rent, the landlords will be made whole through the rental assistance agencies. And so a lot of these tenants who are on fixed incomes, they're going to be collection proof, meaning that even if counsel is hired to pursue these tenants for back rent, there won't be any money there available to pay the landlords. And so in effect, by standing up these rental assistance programs, it's going to help the mom and pop landlords because they're going to receive the funds to keep the tenants in the house.
Thank you.
Thank you. Our next question is from Assemblywoman Mosca.
Thank you, Chair, and thank you for this important bill. As someone who has also, experienced eviction growing up, can know what the impacts can be for our community, especially representing East Las Vegas with you, Senator. And so my question really is, can you share some of the numbers of what is happening and why we need this for the record?
James Ornshaw, Senate 21. Thank you, Assemblywoman, for the question. Actually, I wonder if I could defer to either Mr. McDonald or Mr. Norman on those numbers that I don't have.
I think Mr. McDonald is there every day, so I think, and he has a handle on what our self-help center is seeing all the time. So, Mr. McDonald.
Well, thank you for the question. We saw 30,000 evictions last year in Las Vegas Justice Court alone. And so that was almost double year over year what we typically see. As far as the Justice Court, they typically see tens of thousands of folks coming through the door every single year applying for rental assistance. As far as eviction diversion court, it's my understanding that the court is scheduling 50 meetings per day, Monday through Thursday. And so we're looking at approximately 200 folks in Las Vegas Justice Court who will have eviction diversion meetings before having an eviction hearing, these non-payment of rent cases. Thank you.
And then Jonathan Norman, for the record, I'll just add, the Legal Aid Center operates the Civil Law Self-Help Center, which has the, at the Regional Justice Center, and they see between 300 and 500 people every day coming in because over 90% of those are eviction cases. So if you think about the volume, if we, spread that over a year, we're talking, tens of thousands of people.
Thank you for that. Our next question is from Assemblywoman Gallant.
Thank you, Chair. Thank you for bringing this forward. I have gone through the rental assistance process over the last 2 years pretty intimately, and so I understand how this works. And just for clarification, Mr. McDonald, in order to expedite the rental assistance process, we had to file the eviction. I've asked for numbers on how many actual lockouts happened, so I think that was a little misleading, but I will move on. In terms of one of the things that we struggled with and that we're still struggling with within the courts is that AB 486 required that we accepted that rental assistance. And now we've come to the end. And something happened that we didn't intend, and that happens frequently, right? So the judge is up there. The tenant only has 5 months left of rental assistance. She's been in the property for 10 months. And legally, the landlord has to accept these funds, but there is statute that says we're not allowed to accept partial payments and move forward with the eviction. But the courts are so far out that it's at this point, it's like an undue burden on the landlord. I mean, many of my landlords carried, these rents or these mortgages for over a year before we had any idea whether we were going to get rental assistance. So now the judge is having to use judicial discretion to say, hey, if the tenant doesn't have the remaining money in X amount of days, like I'll still grant the eviction. So my question is would you consider adding another addendum, I'm sorry, to in the event that we are in a situation with the rental assistance, the courts are backlogged, the tenant doesn't have the remaining money by the time the landlord receives the rental assistance, and the court date is like 2 months out after the rental assistance has covered those other 2 months. If you can grant, in those cases, the judge to allow the eviction to continue with the landlord accepting partial funds, just meaning the rental assistance, not the tenant's money, so that it reduces some of the burden on the landlord to go through this process, because they have carried a lot of this burden over the last 2 years. And I guess my thought process is greater good, so that if, you're not making this such an arduous and like tedious and tenuous market, the landlords are more likely to stay, which we need them to, so that these tenants have housing. So I'm just wondering if that would be something you would consider.
James Ornshaw, Senate 21. Assemblywoman, thank you for the suggestion. We've been working, with Mr. Norman and a lot of stakeholders. I'm certainly open to other ideas. As to that idea, I think maybe I'd like to defer to Mr. Norman and or Mr. McDonald, their opinion on it right now.
Yeah, I'll jump in, Jonathan Norman for the record. So I asked the courts how they would deal with this situation. So, and just so everyone, we're talking about the same thing. So if we have the program where you get 2 months of rental assistance, right? And it actually, before you can get the rental assistance, so you have a court date, let's pretend it's 65 days out. Well, you were owed rent when that started, right? So by the time we get there, you're probably at 3 months, and maybe there's only 2 months of rental assistance. And in the bill, it says that the tenant has to be able to come up with that other month. So we get 2 months of the rental assistance, and I asked, does the court date get vacated? What would we do in Las Vegas Justice Court, which is the only place we have, a program right now? And they said they would maintain that court date, and the tenant would have had to cure that 3rd month before that court date, or they would be evicted. I think we're open to, if there's, there's always that line between micromanaging courts and giving judicial officers discretion. I think, I think we're open to that discussion, and so that's how Las Vegas Justice Court would handle that case right now.
So in terms of the program, if the tenant's denied, like the grant program has determined that they can't continue to pay the rent. So then the tenant is denied that. Is the court date then expedited, or does the landlord have to wait those 3 months essentially?
Jonathan Norman for the record. So if I understand the question, so let's say the tenant, let's just say they don't cooperate, right? They don't show up at that 15-day diversion date, right? What happens? Is that, would that be a fair way to?
Yeah, if they don't show up to the 15-day, or maybe we know that they're not going to qualify, however it's determined within that first month.
So right now in, I guess it would depend on the jurisdiction. So in Las Vegas Justice Court, which again handles 70%, they would maintain that court date. And the reason that, it may seem like that is not a a good thing for landlords, but the ordinary course right now in Las Vegas Justice Court, they're getting hearings at about 75 days. They will have the hearing faster through the diversion program because they're going to be set no sooner than 60. If the court, I don't know that they have the ability to set those faster. I certainly wouldn't object, but right now the ordinary course is around 75 days. So that diversion court date is, for the eviction, is a faster court date than a landlord would get in the ordinary course. So, I mean, it doesn't, so I'm saying they're not going to reset it in the ordinary course and go another 75 days out. They're going to maintain that 60-day date, which is sooner than they would have gotten a court date had this case not been diverted.
Okay, thank you. Our next question is from Assemblywoman Hardy.
Thank you, Chair, and thank you for being here to discuss this today. My question is, it was mentioned there, and last year there were 30,000 evictions in Clark County. So I'm just curious, how many of those were repeat filers? And so if you could answer that. And then also, how long does it take approximately for an application for rental assistance to be processed?
This is Jonathan Norman for the record. I think that some of those, the first part of your question was, sorry, could you repeat it, Assemblywoman Hardy?
Yes, regarding the 30,000 evictions that were filed, how many of those are repeat filers?
Jonathan Norman for the record. I don't think the legal aid providers, I don't think we would have an idea of how many of those are repeat filers. And then the second part of your question was how long the applications take to process. So the CHAP era program ended on January 22nd, and I do not think they have completed processing the applications filed on January 22nd. So if, we are in May, right? So that's quite a bit of time, but again, that was a program open to anybody that had a COVID impact, and so the volume of cases was much higher than what we're going to see in these new programs. And I don't know if Mr. McDonald has anything to add on how quickly the 2 rental assistance programs that are currently live are processing applications. And I don't know if the county would probably be in the best position to answer whether staff will be diverted once the CHAP program is truly ended, because remember, they took applications up until January 22nd.
Yes, thank you, Jonathan. So anecdotally, we first started having eviction diversion meetings in person last week. I have been seeing tenants approved or denied for rental assistance as quickly as this week. And so, these new programs are much more narrow in scope, and it's easier for Clark County Social Services to screen them for eligibility. And so for the new programs, I am seeing decisions in some of these cases within a week, but Clark County Social Services would be the people to ask about how long they anticipate the rest of the applications to be processed.
Quickly, please.
Thank you, Chair. And then I was just curious, when I worked in the Justice Court, they had a hearing master that did the evictions. And so I'm just wondering, now with the diversion court, is that still, you have one, judge hearing doing the diversion court and doing the regular eviction court?
Jonathan Norman for the record. Yes, we say diversion court. It's really a diversion meeting nested within the Justice Court. So there's not a new hearing master. There's not a new, they may have a special calendar which they'll run for these cases, but there's not a separate court for it. Thank you.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for bringing this essential bill. I really appreciate you mentioning that we're still in an eviction crisis, and we know that rents are skyrocketing, and I appreciate that you are trying to tailor this and ensure that all parties are protected. We know that at least 30% of houses in Clark were bought by out-of-state corporate investors. That's not even counting the in-state corporate investors. And so while I appreciate the concerns about mom and pop investors, I also want to make sure we're protecting people against predatory practices. And so with that in mind, I want to know what other programs there are besides Clark. Are there any other rental assistance programs in the state? And is there anyone looking to prop up those programs? And if no, what other states are doing something similar to what you're proposing with this legislation?
Jonathan Norman for the record. So I believe in the city of Reno operates a rental assistance program, and it can be a misnomer to think it's just the city of Reno. I think it's available in the surrounding areas, and I know that was an amendment. I haven't tracked where that came with the appropriation to appropriate additional funding to that group, and I think it touches on some of the rurals up here. And then the second part of your question is what other states are doing. And again, eviction diversion courts are the trend, nationally. The numbers are growing, whether they are statutorily set up or judicially set up. And so I think the trend is to have these programs to maintain housing around the country, and that this is not an idea that we are piloting here. It's something that, and I'd have to go back to the beginning of my remarks, but I think I said there were 180 programs in 36 states. Thank you for the question.
Just for the record, Mindy Elliott with the Flint Judiciary Government Affairs, Assemblywoman LaRue Hatch, I am happy to provide that data for you from both the Reno as well as the rurals.
Thank you. Our next question is from Assemblyman Urick.
Thank you, Chair, and thank you for the presentation this morning. I have a question. By the way, I really appreciate the balance of what you guys are trying to strike. It's a difficult balance between the landlords and what we see in some like corporate greedy landlords, and we know the mom and pops that are out there that are just trying to survive on this money. And so it's a difficult thing. So I applaud your efforts to try to work through this challenge. I know that we are not a finance committee, so my question was, it's related to some finance, but it's really going to get to heart of policy, Chair, I promise. The number that you came up with, if I heard correctly, I apologize, I'm reading through these amendments and trying to figure everything out, but it sounded like there was a $22 million biennium appropriation to help fund as these CHAP funds are running out to do this. I'm curious as to how you came up with that amount, and with the number of evictions that we have, the average amount that they're paying, 2 months, if that's the average that we're doing, and what those costs are. And then, so to kind of help me understand that, and then what happens if this program, if that funding runs out?
Jonathan Norman, Nevada Coalition of Legal Service Providers. Thank you for the question, Assemblyman. I believe Clark County came up with the number for $22 million. I know that was heard or presented in finance, and they had their rationale behind that number, and I don't have that with me today. And same for the city of Reno. They had asked for, I think, a $4 million per year of the biennium. And then I think the second part of your question is what happens if rental assistance is no longer available? If there is not rental assistance, there is not the defense. The defense is contingent upon there being rental assistance. Now, I think the eviction diversion court, if we flip to section 9.5, says that the court may consider without limitation whether the tenant is eligible for any programs, and that would include rental assistance, but I do not. So the court shall. I think they would be able to still stay the case and connect that tenant to wraparound services. even without the rental assistance for that period of time.
Quickly, and I'm also going to ask that you provide very concise responses because we're right now looking at the amount of testimony ahead of us, and we do have floor today, so we need to make sure that we're on the floor.
Okay, yeah, and so I guess it could probably be a one-word answer, but it sounds like from that and from my reading of it, it looks like that then it would just basically, we're going to shift a big burden of this to, if that were to happen under that scenario, then the burden of a 60-day now is going to fall on the landlords, correct?
Jonathan Norman, for the record, I would say that a landlord who files a case in Clark County is going to get a court date at 75 days under the eviction diversion court program. Right now, they're going to get a court date set sooner than that. So they're going to, now that could change if the number of eviction lets up, if we get more court staff, more judges. I'm sure they can lower that timeline, right? And I'm sure they would love that. But right now, if you file an eviction and you're at an eviction diversion court in Clark County, you're getting a court date at 75 days.
Thank you. Our next question is from Assemblywoman Newby.
Thank you, Madam Chair. My question, and thank you for this bill. Thank you, Ms. Elliott, for the amendment, because that was my biggest concern about the voucher programs, knowing the length of the waiting list. Section 9, in the beginning of the amendment, you struck designated and went to summary, rather, and then struck may and went to must, and then struck the affirmative defense. Could you explain what the series of those changes mean in terms of the court proceedings and what that tells the judge and everyone to do?
Jonathan Norman, for the record, thank you for the question. I think the biggest part is switching from the affirmative defense to that it's an extension of time to pay or surrender. I think that some of the criticism is a pending rental assistance is not a defense, and it is an admission to an eviction, right? Because you're admitting that you cannot pay rent, and that is a grounds for an eviction. So I think functionally, if I'm just thinking, and thinking logically, that this is an extension of that time to pay or quit, that it syncs more with our ideas of what a defense is and what law is. And then the tenant must be granted the extension of time. We didn't want there to be discretion because in that moment, because we are putting in a lot of guardrails that will allow and fleshing out what a good faith application is, and fleshing out those guardrails later in the bill. So we didn't want to have the discretion there. We put it later in the bill in definitions of pending rental assistance. So you can't have an application and be sitting on paperwork that the social services needs to make the determination. That's not considered pending rental assistance application. So thank you for the question.
Thank you for that. And with that, I will go ahead and open it up for testimony. So starting here in Carson City, if there's anyone here that would like to testify in support of Senate Bill 335. And I would ask that everyone, of course, make sure that you state your name and spell it for the record, but also that we keep our comments brief because, as I added, we do have floor today, and there are a number of people in Las Vegas and on the phone line. So with that, please proceed.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS. And I'm the Policy Director with the Progressive Leadership Alliance of Nevada and a founding member of the Nevada Housing Justice Alliance here in support of Senate Bill 335. Our coalition formed after the 2019 session to bring tenant voices directly to the legislature. During the past 2 years, our coalition has conducted community outreach, put on educational trainings on tenant law, assisted in filing for CHAPS, and responding to summary eviction notices. We saw firsthand that the protections which were passed in AB 486 at the end of the 2021 session kept Nevada families housed, kept Nevada families together, and kept Nevada families healthy. It is imperative that we continue to utilize these proven methods to ensure housing stability. In fact, housing stability is the foundation for children's educational success, positive health outcomes, economic opportunity, and equitable, vibrant communities. Our communities cannot thrive when Nevadans are struggling to maintain safe, secure, and affordable housing. We urge your support of Senate Bill 335 to ensure every Nevada has a place to call home and can thrive in dignity. Thank you.
Paul Catha, CATHA with the Culinary Workers Union Local 226. Culinary union members are still recovering from the effects of the pandemic. Thousands received rental assistance during the pandemic, and many were protected by the AB 486 defense. We think it's good for the state to continue making sure that folks who are getting rental assistance from the state aren't evicted while they're waiting for that money. The Culinary Union urges the committee to support SB 335. Thank you.
Good morning, Chair, members of the committee. Serena Evans, Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. I'll say it till I'm blue in the face that housing justice is violence prevention and intervention, and just want to remind you all that in 99% of abusive relationships, victim survivors of domestic violence experience economic abuse, and this abuse often negatively impacts every aspect of their life, including their ability to house themselves. So we know that safe and stable housing is the key for individuals being able to leave their perpetrator and rebuild their lives. Programs like these are a critical step in keeping individuals safe and stable. We urge its passage. Thank you.
Good morning, Chair and members of the committee. My name is Annette Magnus, for the record, and I am the Executive Director of Battleborn Progress. We strongly support SB 335 and thank Senator Orenshaw for bringing it forward. Families who are summarily evicted do not have proper due process, and the current process is contrary to civil procedure. At a time when Nevada is facing a housing and homelessness crisis, working-class Nevadans are struggling to get by and still recovering from the pandemic. We have to do everything we can to bring relief, and this bill does just that. This bill is critical. I saw firsthand this crisis when I ran the food pantry out of my garage during the pandemic. I know Nevadans are still struggling. Please support SB 335. Thank you.
Hi, good morning. Chair, members of the committee, my name is Chastity Martinez. That's CHASITY-MARTINEZ. I am a resident of Reno in Assembly District 27. I'm also an organizer with Faith in Action Nevada, and just want to come here to offer our support for SB 335. We believe that housing is a human right, and we know more and more of our community members are falling into homelessness because of this eviction process and because of the lack of support there. So really just urge you to please support this bill and support any compassionate solutions for people in our community. Thank you.
Is there anyone else here in Carson City? Not seeing anyone? Is there anyone in Las Vegas that would like to come and testify in support of Senate Bill 335? Not seeing any. Is there anyone approaching? Not seeing anyone. Broadcasting, will you open the lines, please?
To testify in support of Senate Bill 335, please press *9 now to take your place in the queue. Caller with the last 3 digits 510, you are unmuted and may begin.
Hello, this is Lilith Thurn with the ACLU of Nevada, LILITHBARAN, and we are in strong support of SB 335. Thank you.
Hello, good morning to members of the committee. My name is Sean Navarro. I just want to call in and support this bill. Please pass it. And in the interest of time, I just quote Smokey Robinson and say I second that motion to the folks supporting this. Thank you so much.
Good morning, Chair Miller and members of the committee. My name is Shelley Speck. That's SHELLY-SPECK, and I live in Gardnerville, Nevada. I am providing testimony today on behalf of the Children's Advocacy Alliance and the Nevada Strong Start Coalition. In order to prevent families from slipping into homelessness, we must ensure tenants are giving clear and concise instruction on how to respond when receiving an eviction notice so they can take appropriate corrective action. Since evictions have become commonplace statewide due to a lack of oversight and competition for properties, tenant protection is needed now more than ever. Many tenants are unable to navigate the legal jargon of an eviction notice to be able to address it. This results in tenants or families misunderstanding the process, eventually self-evicting, and then waiting in limbo for alternate housing when they could have been connected to crucial resources and interventions early on. The stress of tenant evictions affects families and children. By streamlining the eviction process and removing barriers to prevention, children will have a better chance of achieving stability and successful outcomes when they are less likely to be thrown out into the streets. It is unimaginable that families were evicted so easily this past year in northern Nevada during the coldest winter within the last 50 years. When we can first secure housing, then we can ensure the health, safety, and well-being of children. Ask yourselves, what can I do to prevent another child from becoming unhoused? When you leave here today, please make a commitment to reorganize the eviction process in existing law and support SB 335. Thank you.
You have recently joined and would like to testify in support of Senate Bill 335, please press *9 now.
Hello, my name is Shanika Cooper. That is Shanieka. Last name is Cooper, Cooper. I am calling in support of SB 335. My family and I have been directly affected by the eviction process, and I urge you to please support this bill. Thank you, and have a good day.
There are no other callers choosing to testify in support at this time.
Thank you so much. Then with that, I will open it up for testimony in opposition of Senate Bill 335. Starting here in Carson City.
Good morning, Chair and members of the committee. My name is Tiffany Banks, and I'm General Counsel for the Nevada Realtors. We are testifying today in opposition of SB 335. We would like to thank Senator Orenshaw for continuing to work with us on this bill and get us to a place where there is a fair and balanced approach for both landlords and tenants alike. As you may be aware, our mom and pop landlords do not want to have to evict their tenants, and in fact work with their tenants doing everything they can to not get to the point of eviction. We want to clarify for the record that the data shows that rents are actually declining and not skyrocketing. We have concerns with this bill as drafted, specifically Section 9 that sets forth a process whereby the tenant is granted an extension of time to stay the proceedings. We are very concerned that without specific timelines set forth how quickly the county must process these rental assistance applications, that they may not be processed in a reasonable amount of time. Further, in order to grant the landlord's motion to lift the stay of the eviction, the court must find evidence that the landlord faces a realistic threat of foreclosure, as well as the other things named. If the landlord is facing these scenarios, they are already so close to risk losing their property or having the ability to become current on their mortgage because of the lengthy default period for the payment of rent. There are many other scenarios where hardworking landlords can suffer. If they themselves are elderly, for example, living on a fixed income, relying on the tenant's rent to support them, this makes it impossible for them to afford to repair the property. Many rely on this rent to survive. There must be a sunset to Section 9 so we can be sure that the county is able to adequately process rental assistance applications as they come in, be sure they are staffed, the staff understands the actual process, as well as be sure there is funding, and the funding can be replenished if it runs out. We support the work, I'm trying to talk fast, and development of the diversion program set forth in Section 9.5 of this bill. We just have a few outstanding questions regarding the fast track of the evictions if the tenant fails to show up to the diversion program or doesn't provide the necessary documents. We believe in connecting those
I'm going to ask that you wrap it up.
Okay, with the right programs and services that actually work. As you see, there are some difficult issues. We will continue to work with the bill sponsor and legal aid to address these issues, and thank you for your time today.
Good morning, Chair and members of the committee. Dylan Keith, KEITH with the Vegas Chamber. We'd like to largely echo the sentiments raised by Ms. Banks and the Nevada Realtors Association. We would also like to thank Assemblywoman Summers Armstrong for her work on AB 340, which largely mirrored this legislation. We were able to find a decent spot to work with, but we do stand in opposition to this bill at the moment. Thank you so much.
Thank you. May I ask, did you support Assembly Bill 340? No, okay. But you appreciate her cooperation. Okay, thank you so much. Is there anyone else here in Carson City that is in opposition to SB 335? Not seeing anyone? Is there anyone there in Las Vegas in opposition of Senate Bill 335? Okay, I see someone approaching.
Good morning, Madam Chair and Committee. My name is Brenda Lovato, BRENDA LOVATO, and I am here representing the Institute of Real Estate Management and General Services, the company in which I work for. Senate Bill 335 further negatively impacts the housing industry. It extends AB 486 indefinitely. AB 486 has had a profoundly negative impact on the housing industry and has significantly disrupted the ability of the courts to move eviction cases in a timely manner. The pandemic is over, and all the other businesses have been allowed to return back to normal. That is the reason why AB 486 was originally put in place, was for the pandemic. I could go on and on, which I'm not going to due to time, but I could go on about all the horror stories that we have experienced. As one of the presenters said for the bill, they have said how long we still have applications that are in January that have not went through the queue, so we don't know if we are going to get the rental money. So I am asking for relief for our industry and oppose Senate Bill 335. Thank you.
Thank you so much. Okay, so those who wish to testify, we would encourage you to, you don't have to wait one at a time. You can just fill the chairs, and then that way we're able to expedite quickly through our testimony. So if there's anyone else wishing to testify in opposition, I would encourage you to just keep filling those chairs. And with that, next person, please continue, please.
Hi, my name is Ruth Garcia. I'm with Westland Real Estate Group. Ruth, R-U-T-H, Garcia, G-A-R-C-I-A. I want to echo what Ms. Banks said. We all have suffered through this whole process of CHAP applications, and it takes many months. We have residents that owe us $7, $8, $10, $15, even $20,000. This program that you're talking about isn't going to help us with that. This is only going to cover 2 months. We're never going to get these residents to pay that amount, and the courts are just holding us up. We are definitely in opposition of 335.
Good morning, Madam Chair and members of the committee. My name is Mike Parrish, M-I-K-E, Parrish with one R, P-A-R-I-S-H. I was kind of conflicted on which presence I would present today because I stand with a foot in both parties here. I'm a real estate broker presently. I'm a former mortgage banker. I'm a former landlord. I'm also formerly homeless. And I also started a nonprofit, Credo LV, which is Community Revitalization Economic Diversity of Las Vegas, back in 2018. I've seen the frontline effects of homelessness, and there are two matters that haven't been discussed in all the testimony that I've heard this morning, which I wish to bring to your attention. There are two words that sum this up quite simply, and that's rent control. One need only look at San Francisco, Los Angeles, and New York City to see how effective that is. The other is that we talk of these families and these individuals who will be displaced for non-payment of rent, but that doesn't take into account the tens of thousands of individuals who are currently homeless, who have no place to be sheltered, who already have a voucher, and the vouchers are expiring because there's a lack of available housing. Those individuals deserve the same chance to get on their feet as the people who are not paying rent. Lastly, on that point, it was stated previously that the vast majority of these landlords are in fact moms and pops. 30% of the vicious, evil corporate landlords, while 70%, the overwhelming majority, are moms and pops. Let's not forget that when these folks miss their mortgage payments, they end up not being able to get requalified for housing either. What happens when they become homeless because they can't pay their bills and their credit's destroyed? They're forced to file bankruptcy. What we're doing is shifting the burden from people who are trying to do best by not only themselves and their neighbors, but shifting it to them from those who have had ample time to vacate the premises. Perhaps a provision can be put into place that folks would have to notify or apply for assistance long before 2 months of not being able to pay rent. Oftentimes, they already know what their financial situation is well in advance. Thank you for your time.
Please begin when you're ready.
Thank you. Good morning. My name is Robin Lee, Robinlee. I'm the Executive Director of the Nevada State Apartment Association. Our members supply just shy of 180,000 housing units in this state. They employ thousands of Nevadans, and they are certainly not in the business of kicking people out of their homes. They are in the business of keeping people housed. Eviction is always the last resort. SB 335 seeks to solve a problem, but it proposes to solve it in the wrong place and time. Using rental assistance programs to delay an eviction once it has reached the court is too late and it's backwards. Several of our members offer affordable housing options in the North and the South, and the state desperately needs more. As a long-term solution, let's figure out how to get more affordable housing developed, and as a short-term solution, let's figure out how to work together to pool our resources, to bring awareness to Nevadans about the programs that are available to them as a preventative measure. We are not the enemy, we are an ally. And we ask that if the time comes, you vote no on SB 335. I know you see a lot of people behind me in this room here in Las Vegas, and not all of them are going to speak. So at this time, I'd just like to ask if anyone agrees with my testimony behind me, if they would please stand. And I thank you very much for your time.
Thank you so much. Please proceed.
Good morning. My name is Chris Carsaz, K-A-R-S-A-Z, with Carsaz Law. We are legal counsel for the Nevada State Apartment Association, and we represent many housing providers throughout the state. I am here to testify in opposition to SB 335 for 3 primary reasons. First, the bill delegates the legislature's role of making policy to the judiciary for the purpose of creating eviction diversion programs. It is extremely dangerous to do so, as the judiciary is supposed to be an impartial arbiter of disputes, not to craft policy and to be lobbied by stakeholders. We had to deal with this last year, when, as a result of the Wells Fargo grant of money, the Las Vegas Justice Court developed an eviction diversion program, the first draft of which substantially changed NRS 40. It was only due to our objection of due process and separation of powers that it was further amended and later adopted by the Supreme Court. The Judicial Code of Conduct requires judicial officers to avoid the perception of bias, as it would erode public confidence in the institution. We should protect the judiciary's role as an impartial arbiter of disputes and maintain this body, the legislature's role, in creating policy. The public needs to have confidence that each branch of government is doing their role in our democracy. Second, there's a great moral hazard with extending AB 46. We saw tremendous abuses in the last several years, and the brunt of it had to be borne by good housing providers and good tenants who ultimately pay the price. There were many people who checked the box because they were able to get a delay of many months. Checking the box to get free rent is not a way that we should craft policy. We definitely agree that the government should provide a social welfare net for those in need, but it shouldn't be transferring that responsibility to private citizens. It has a chilling effect on housing providers, and we need them to solve our housing crisis. And finally, I have a comment regarding the fiscal impact of this bill. I am not a political advisor or expert by any means, but my understanding is that there's no fiscal note, therefore consequence of this bill. And that's not true. There is a cost. We have attorneys in courts
Okay,
throughout
I'm
this
going to ask that you
state.
wrap up your comments, please.
Sure. The delays that are being talked about by Mr. Norman and others are as a result of short staffing. They don't have the human power. And we are being asked as landlords to bear that cost. That is improper. Thank you. We hope that you join in opposition to this bill.
Thank you. Is there anyone else wishing to provide testimony in Las Vegas? Okay, thank you. And I will let you know that for all of you who did stand up, that will be put into the record that we had that visual of your opposition. So thank you for that. With that, I will move to the phone lines. Broadcasting, would you please open the lines?
To testify in opposition of Senate Bill 335, please press star 9 now to take your place in the queue. Caller with the last 3 digits 829, please press star 6 to unmute your phone. Again, caller with the last 3 digits 829, please press star 6 now to unmute your phone. Chair, this caller seems to be having issues unmuting their phone. Would you like to move on?
Yes, please. And if they're able to get back in, even if we're on neutral at the time, we understand the technical challenges sometimes. So yes, please, let's just move on.
There are no other callers choosing to provide testimony in opposition at this time.
Okay, thank you so much. And again, if that person's able to connect once we get to neutral, we will accept them in. With that, I will open up neutral testimony here in Carson City. Is there anyone that would like to testify? Not seeing anyone. Is there anyone there in Las Vegas that would like to testify in neutral? Not seeing anyone approach. Broadcasting, will you open the lines, please?
To testify in neutral to Senate Bill 335, please press star 9 now to take your place in the queue. There are no callers choosing to provide testimony in neutral at this time.
Okay, thank you for that. So with that, I will go ahead and close testimony and welcome the bill presenters back up for any final remarks.
Chair, members of the committee, thank you for your patience for this lengthy hearing. I believe Senate Bill 335, as we've amended it over in the other house and proposed to amend it today, really is a balanced approach that tries to protect tenants and protect landlords. And I hope the committee will consider moving it forward. I certainly am open to other ideas. We have had some other ideas suggested today. And with your permission, Chair, if Mr. Norman could also address some of the comments that were made.
Thank you, Chair, members of the committee. One, I would just like to point out, there was an article declining rents. They declined by 1% after we saw like historic, rising rent. So the difference between that 1%, a 200-degree baked potato, 1% difference is a 198-degree baked potato. It's still too hot to eat, right? We've had rents go up at historic levels. So, and then there was a comment that 30%, I think it was from Assemblywoman LaRue Hatch's comment that 30% of homes were purchased by out-of-state landlords, and a commenter had conflated that with 30% of the homes in the state are owned by corporate landlords, and therefore 70% are mom and pops. It's 30% of the homes purchased in the state have been purchased by out-of-state landlords in a given period of time, is I think where that comes from. This bill, while I think there's a lot of trauma from landlords from the CHAP program and the extensions of time that were associated with that program. This program is narrowly tailored to fit, and the extension is very small. We're not going to have 8 months. We have 60 days in the eviction diversion program. Mr. McDonald stated that they're seeing those applications approved in a week or 2 weeks. We just are not going to have the same volume, and we're not going to have the same extension of times. We've put significant guardrails so that the tenant has to show that they can pay the additional rent beyond what is provided in rental assistance. So we've tried to strike that balance. And then I think there was I wanted to make sure that everyone understands that justice courts may set up these programs. They don't have to set up these programs, so this is permissive language that they may set up the programs. And then, the idea of eviction diversion programs being popular and a good idea. So the Las Vegas Justice Court, when they applied for that state court grants, they had letters of support from many in the opposition today for diversion court grant. And I think in the testimony on the ADKTs, I think there were about 80 pages of opposition. And throughout it, they said the court should not do this. We should wait until the legislative session for this body to act and create eviction diversion court. And that's exactly what we're doing in this bill. I went back through those documents last night, and I noted at least, 5 to 10 places where they specifically said, the court should not act, the legislature should act on things like eviction diversion. And that's why we're here with this bill. And I think eviction diversion programs are vital to keeping people housed and making sure that state money goes the furthest and makes a difference for our community. So thank you for the time, and I appreciate, I know this was a long hearing. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 335. The last thing we have on our agenda today is public comment. So if there's anyone here wishing to make public comment in Carson City, please come forward. Anyone in Carson City that would like to make public comment, please come forward. Not seeing anyone. Broadcasting, will you open the lines, please?
To provide public comment, please press star 9 now to take your place in the queue.
Hello, my name is Susan Profit, and I'd like to ask your permission to have a neutral comment on the last bill, because I tried twice to get through this morning, and both times my cell phone number was not accepted, so I'm calling from a different number. May I be neutral on this bill?
Oh, okay, I will accept your neutral, but the hearing's actually closed, but I will have you documented as neutral. Thank you.
All right. Wait a minute.
Okay.
I'm not done with my neutral
Okay,
comment.
but ma'am, I did not open up or grant neutral. I just said that we will document you as neutral on the bill. The bill hearing is closed. We're
All right,
in public
I appreciate
comment.
that, but now may I have
Okay, next caller.
May I have a public comment?
Yes, you may have
I have a public comment?
Ma'am, you may have a public comment, but public comment is, the intention of public comment is for issues under the purview of the committee, but not related to any bill hearings. So please continue with your public
All right.
comment.
Yes, that's what I would like to do.
Please
All right.
continue.
My 2 minutes started. All right. First of all, I am a little concerned by the number of bills that are being passed that have very high opposition numbers, and I'm talking 85 to 99%. I'm concerned because it doesn't appear to reflect the will of the people, and I wish you all would reflect on that before passing a bill without looking at the details, which I wanted to present to you in a way that could fix the bill you just spoke to. But there's one more thing I'd like to ask you. Please bring AB 405, the Lombardo's bill for voter ID, to the floor. I believe it is being grossly out of line for you all not to even allow this bill that has over a 95% approval rating to come to the floor for a vote. So please show our governor some respect and respect your constituents, please. I appreciate your time. Thank you.
Thank you. Next caller.
There are no other callers choosing to provide public comment at this time.
Thank you so much. Then with that, thank you, members. We do have floor, so everyone knows where they need to be and what they need to do, and I will see you. Just so that everyone knows too, the work session, the agenda with the work session items will be posted soon today. Just so everyone knows, we will have a number of items on work session tomorrow. And with that, I will see you back at 8 a.m. tomorrow morning. This meeting is adjourned. Yeah, let me just, I have to see the, you're welcome.